On the evening of Easter Sunday, the 10th of April 1955, a shot was fired outside a public house in North London. The weapon was a black Smith & Wesson revolver. The place was the Magdala at the foot of South Hill Park in Hampstead. The time was about 9:30. A racing driver named David Blakely fell in the street. A woman stood over him and did not run. When an off-duty policeman reached her, she handed him the gun. She told him, in substance, that she was guilty and a little confused. Her name was Ruth Ellis. She was 28 years old. She managed a drinking club and wore her hair bleached platinum blonde. She never denied the killing, not that night, and not at her trial. The question this case turns on is not who fired the shots. She answered that herself in one plain sentence in a courtroom. The question is what a modern country did next and whether it could live with the answer. Before we go further, take a moment to subscribe and turn on the notification bell so you never miss a case like this one. Now, back to Hampstead. London in 1955 was a city easing out of hardship. The war had been over for a decade. Rationing had ended the year before. There was more money in some pockets now. A world of small drinking clubs, motor racing, and hard-drawn class lines sat on top of the older austerity. Ruth Ellis moved through that world. She managed the Little Club, a members' drinking club on Brompton Road in Knightsbridge from 1953. It was a place of late hours, spirits, and easy company. The law she lived under was not easing at all. In England, murder carried a mandatory death sentence on conviction. A judge who found a defendant guilty of murder had no other sentence to pass. There was no defense of diminished responsibility in 1955. That idea did not enter English law until the Homicide Act of 1957, 2 years too late for her. The only partial defense that might reduce murder to manslaughter was provocation, and it was narrow. The law required a sudden and temporary loss of self-control, measured against an imagined reasonable man. A person who found a weapon and went to confront another did not fit the rule. Serious trials of this kind were heard at the Central Criminal Court, the Old Bailey. Executions were carried out by hanging inside prison walls by executioners appointed by the Home Office. The science of the day was basic. There was a post-mortem to establish cause of death. There was ballistic work to link a recovered weapon to a scene. There were witness statements taken by hand. There was no DNA and little in the way of scientific reconstruction. In a public shooting before witnesses, none of that was needed to name the person who fired. It would matter instead where the gun had come from. Ruth Ellis was born Ruth Nielsen on the 9th of October 1926. Her birthplace was Rell on the coast of North Wales. Her father was a musician who worked under the name Arthur Nielsen. The family's true surname was Hornby. They later moved to London. Ruth grew into a young woman who found work first as a photographer's model and then as a nightclub hostess. She had a son, Andre, born in 1944. His father was a Canadian serviceman. For a time, she married a dentist named George Ellis. A daughter, Georgina, was born in 1951. The marriage failed, worn down by his drinking and his jealousy, and she kept his name. By 1953, she was managing the Little Club. It was there, in the racing and club set that drifted through Knightsbridge, that she met David Blakely. He was born on the 17th of June 1929 in Sheffield. He was a racing driver, charming, and a heavy drinker. He was reportedly educated at Shrewsbury School. He was building and racing a car that he had nicknamed the Emperor. He was also on the record violent toward her, and he was engaged to another woman even as their affair ran on. Their relationship was intense and unstable from the start. It was jealous on both sides. It ran alongside Blakely's engagement and alongside another attachment in Ruth Ellis's life. That was Desmond Cusson. Cusson was a former Royal Air Force pilot who had flown Lancaster bombers in the war. He worked afterward as a company director and accountant. He was steadier with money than Blakely and calmer in temper. Ruth Ellis and her son lived with him at times at his flat at Goodwood Court in Marylebone. His name would return at the very end of the case over the question of the gun. Through 1954 and into early 1955, the affair with Blakely broke down by degrees. There were repeated rows, there was heavy drinking. There were separations and reconciliations that never held. She lost the management of the little club, and with it a measure of her independence. The two of them could neither settle together nor let each other go. Then came the injury that sits at the moral center of the whole case. Early in 1955, Ruth Ellis was pregnant. During an argument, Blakely struck her in the stomach. She miscarried. That is the fact, stated once and plainly. It is the pivot on which every later argument about her state of mind would turn. It is the reason the case would trouble the public conscience so deeply. By the Easter weekend of April 1955, Blakely was trying to keep away from her. He was staying with friends named Anthony and Carol Findlater at their flat at 29 Tanza Road in Hampstead. Ruth Ellis believed they were keeping him from her, whether that was true or not. She was distraught and could not sleep. Over the long weekend, she searched for him around Hampstead. She went to the streets where she thought he might be. The tension of those few days built toward the Sunday evening. If you are finding this as unsettling as it was at the time, consider a like and a subscribe. It helps us keep uncovering these forgotten cases. Now, back to the record. On Sunday, the 10th of April, Blakely spent part of the evening drinking at the Magdala with a friend named Clive Gunnell. The Magdala was a public house on South Hill Park near the foot of Hampstead Heath. The two men were inside for a while. When they came out at about 9:30, Ruth Ellis was waiting in the street. What happened next took only seconds. She fired the .38 Smith & Wesson revolver at David Blakely at close range. He died there in the road. That is the clinical account, and it is the only one needed. One of the shots went wide. It struck the pavement or a nearby surface and ricocheted. The stray round hit a passerby, a woman named Gladys Ewell. She was walking to the pub with her husband, Donald. She was wounded in the hand and permanently lost the use of her right thumb. She is the case's forgotten casualty, an ordinary woman injured by a shot never meant for her. Ruth Ellis made no attempt to escape. She did not flee into the dark of the Heath or the side streets she knew well. She stayed where she stood. An off-duty police officer, Constable Alan Thompson, had been drinking in the Magdala. He came out, took the revolver from her, and arrested her on the spot. By her own later account, she told him she was guilty and confused. There was no chase, no manhunt, no mystery about identity. Within minutes of the shooting, the person responsible was in custody and the weapon was in a policeman's hand. The exact number and sequence of the shots was never settled with certainty. The revolver held 6 chambers, and contemporary reports described it as emptied or nearly emptied. The precise count does not survive as a fixed fact, and it does not need to. What was plain to everyone at the scene was simple. David Blakely was dead. Ruth Ellis had fired, and a bystander had been hurt. Because the killing had happened in a public street, before witnesses, there was no case to build in the ordinary sense. There was no suspect to find, and no identity to prove. The investigation turned almost entirely onto a single question. Where had the gun come from? A nightclub manager does not, as a rule, carry a loaded service revolver. She did not appear to know how to use one. Police wanted to know how the weapon had come into her hands and how she had learned to fire it. On this point, Ruth Ellis was evasive. In her statements, she was vague about the revolver's origin. At first, she suggested only that it had been in her possession, without saying how it had reached her. She did not name a source. She did not explain where she had practiced or who had taught her. The thread was left hanging, and it would stay hanging right up to the last day of her life. The rest of the investigation was routine for the era. Police took statements from the people who had been there. Clive Gunnell had stood beside Blakely and had seen the shooting. The Findlaters could speak to Blakely's movements over the weekend and to Ruth Ellis's pursuit of him. The Ewells could describe walking toward the pub and the moment Gladys was struck. Pubgoers gave their accounts. The recovered revolver was examined and tied by ballistics to the scene. A post-mortem confirmed that Blakely had died of gunshot wounds. None of it was in doubt, so the police had an admitted killing and a recovered weapon. They had a dead man and a wounded bystander. What they did not have was an answer to the gun's origin. That single unresolved thread ran on beneath the certainty of everything else. It would surface again only at the very end, in a statement made too late to matter. Ruth Ellis was charged with murder and remanded in custody. A coroner's process recorded the death of David Blakely. The real contest, though, moved quickly toward the Central Criminal Court. Because murder carried a fixed capital sentence, there was no room for a bargain over the plea. There was no lesser charge the prosecution could offer, and no arrangement the defense could seek. That left only two live questions for the lawyers. The first was whether the defense could persuade the judge to leave provocation to the jury. That might let them bring in manslaughter instead of murder. The second was whether her state of mind, her suffering, and the violence she had endured could count for anything at law. In 1955, the honest answer to the second question was that it counted for almost nothing. The defense would have to try the first, and try it against a doctrine that did not favor them. The trial opened at the Old Bailey on the 20th of June 1955 in No. 1 Court. It was short. The evidence took only about a day and a half. The judge was Mr. Justice Havers. The prosecution was led by Christmas Humphreys, a senior counsel of the day. The defense was led by Melford Stevenson with Sabag Shaw and Peter Rawlinson beside him. Ruth Ellis's original solicitor was John Bickford. The defense strategy was clear, and given the law, almost the only one available. They would try to establish sustained provocation. They would lay out the violence in the relationship, the betrayals, and the miscarriage caused when Blakely struck her. Their hope was that Havers would allow the jury to weigh manslaughter. A jury hearing what she had suffered might spare her the gallows. The eyewitnesses came first in substance. Clive Gunnell had been at Blakely's side outside the Magdala and could describe the shooting as a man standing feet away. The Findlaters spoke to the days before, to Blakely sheltering at Tanza Road, and to Ruth Ellis searching for him around Hampstead. The wounding of Gladys Ewell was before the court as well, the plain fact of an uninvolved woman hit by a stray round. Medical and ballistic witnesses established without drama that Blakely had died of gunshot wounds and that the recovered revolver was the weapon. Then Ruth Ellis herself went into the witness box. Her manner was calm and composed. She did not weep or plead. She answered the questions put to her directly. And it was there, under cross-examination, that the trial effectively ended. Christmas Humphreys asked her what she had intended when she fired the revolver at Blakely at close range. She answered, "It is obvious that when I shot him, I intended to kill him." That single sentence destroyed the defense. Provocation in law required a sudden and temporary loss of self-control. A woman who calmly told the court that she had intended to kill could not easily be shown to have lost control at all. Her honesty, her refusal to shade the truth, worked against her at every turn. She would not say what might have saved her, because it was not what she believed to be true. The decisive question of the trial was never really for the jury at all. It was for the judge. Mr. Justice Havers had to decide whether there was enough evidence of provocation in law to leave manslaughter open to them. He ruled that there was not. Under the doctrine as it then stood, provocation had to produce a sudden and temporary loss of self-control. A defendant who had obtained a gun and gone to confront the deceased did not meet that test. And there was no defense of diminished responsibility to fall back on, because none existed. That ruling settled everything. It meant the jury could not consider her suffering as a path to a lesser verdict. The violence and the betrayals could not reduce the charge. Neither could the miscarriage caused when Blakely struck her. The judge was bound by the law. The jury's task shrank to a single bare question. Had Ruth Ellis shot David Blakely, intending to kill or seriously harm him? She had said so herself in the box without hedging. Havers directed the jury accordingly. The defense had nothing left to argue because the one argument the law allowed had been closed off. The jury retired. They were gone for only a short time, reported at about 20 minutes, with accounts ranging from roughly 14 to 23. When they came back, their verdict was guilty. It surprised no one in the room. The tension in the case had never been about whether she had done it. It was about the rigidity of a law that admitted no other outcome. Because the conviction was for murder, the sentence was fixed. Havers passed the only sentence the law allowed. The sentence was death. There was no discretion for him to exercise, and no lesser term he could impose. A young mother of two had been condemned to hang. She had never disputed the facts. The law could not bend to take account of why she had reached that street with a revolver in her hand. What happened outside the courtroom then moved faster than anyone expected. Public unease grew quickly. The image at the heart of the case was a plain one. A young woman had been sentenced to death for shooting a man who had beaten her and caused her to miscarry. To many people, that did not sit as justice. Newspapers took up the matter. A petition urging clemency gathered around 50,000 signatures. The pressure built through the days after the verdict and reached the level of the cabinet, then led by Prime Minister Anthony Eden. The decision on a reprieve rested with the Home Secretary, Gwilym Lloyd George. He considered the case and refused to intervene. His reasoning, as reported, was that people could not be allowed to fire guns in the street and escape the consequences. The wounding of Gladys Ewell, the bystander, weighed in that view. A stray shot had struck an innocent woman on a public street, and that could not be set aside. Whatever unease existed at cabinet level, the refusal stood. The execution would go ahead. Then, on the 12th of July, the day before she was due to hang, Ruth Ellis made a disclosure. She had kept it back through the whole trial. Her original solicitor had been John Bickford. Now, two other solicitors, Victor Mishcon and Leon Simmons, came to see her at Holloway. To them, she said for the first time that Desmond Cusson had given her the revolver. She said he had shown her how to use it and had driven her to Hampstead on the night of the shooting. This account has to be treated with care because it was never resolved. It arrived at the last possible moment after the trial and the verdict. The refusal of the reprieve had already been given. It was unsupported by other evidence. The Home Office considered it and let the execution proceed. A later police inquiry looked into the claim and took no action against Cusson. It may have been the full truth or a partial truth. It may have been an effort to reach back at a man she blamed. That cannot now be established. It stands as a last-minute statement and an open question and nothing more. It answered, or seemed to answer, the one thread the investigation had left hanging. But it came too late to be tested, and too late to change anything. On the morning of the 13th of July, 1955, shortly after 9 o'clock, the sentence was carried out at Holloway Prison. The executioner was Albert Pierrepoint, assisted by Royston Rickard. By the accounts of those present, Ruth Ellis met the end composedly. She did not break down. She was 28 years old. She was the last woman to be executed in the United Kingdom, and she remains so. She was buried, as the law then required, in an unmarked grave within the walls of Holloway Prison. There was no headstone and no public marker. Her son Andre was 10 years old. Her daughter Georgina was about 3 or 4. They were left without their mother by the working of a law that could not weigh what she had endured against what she had done. The grave inside Holloway did not remain her final resting place. In the early 1970s, around 1971, the prison was rebuilt. The remains buried within its walls had to be moved. Ruth Ellis was exhumed and reburied outside the prison at St. Mary's Church in Amersham in Buckinghamshire. A headstone was placed over the new grave. It did not carry the name under which she had been tried and hanged. It read, Ruth Hornby, with the years 1926 to 1955. Hornby was her father's true family name, the name behind the stage name he had used. The headstone was later disturbed and removed, and the quiet grave lost even that marker. The man at the center of the last-minute disclosure lived on for decades. Desmond Cusson was never charged in connection with the gun. The police inquiry that followed her statement took no action, and the question of his part was left where it lay. In later years, he emigrated to Australia. He died there in 1991, 36 years after the woman who had named him went to the gallows. Whatever he knew about the revolver and the drive to Hampstead, he took with him. The children were the quietest casualties of all. Andre and Georgina grew up without their mother, marked by a case that would not be forgotten. Her family suffered lasting consequences in the years that followed, for the newspapers did move, and in a direction the authorities had not counted on. The mood that had produced 50,000 signatures did not fade with the execution. It hardened. The press, which had campaigned for a reprieve, now turned its anger on the hanging itself. In the Daily Mirror, a columnist wrote under the name Cassandra. His real name was William Connor. He published a scathing piece against the execution. He wrote in plain fury about what the state had done that July morning. He was not alone. A British Pathé newsreel, seen in cinemas across the country, openly questioned whether capital punishment could be justified at all. That was a striking thing for a mainstream newsreel to do in 1955. The novelist Raymond Chandler, the American writer of detective fiction, was in England at the time. He condemned what he called the medieval savagery of the law that had killed her. Voices that ranged from a tabloid columnist to a celebrated author found themselves saying the same thing. A modern country had hanged a battered young mother, and many of its own people recoiled from the act. The unease had a target that went beyond the individual case. What troubled people was the machinery. The law had offered Ruth Ellis no way to put her suffering before the jury as a matter that could reduce her guilt. It had no category for a mind pushed past endurance. It had no room for the violence she had lived with or the child she had lost. The provocation rule was too narrow to reach her, and the concept that might have reached her did not yet exist. The case exposed that gap in a way that arguments in the abstract never could. Here was a real woman, named and photographed, hanged inside those rules. That pressure fed into reform, though it was one force among several rather than the single cause. 2 years after her death, Parliament passed the Homicide Act of 1957. It introduced a defense of diminished responsibility into English law. It also reworked provocation, softening the rigid doctrine that had shut Ruth Ellis out. These were precisely the two doctrines whose absence had doomed her. A defendant in her position, tried after 1957, would have had arguments to put that she never could. The change did not stop with that act. The direction of travel was set, and it ran toward the end of the practice entirely. The last executions in Britain took place in August 1964. 2 men hanged on the same day. After that, the rope was never used again. The following year, Parliament passed the Murder Abolition of Death Penalty Act of 1965. It ended capital punishment for murder across the country. The gallows that had waited for Ruth Ellis and for the many condemned before her were retired from the work of the courts. Her place in that story is fixed by a single fact. She was the last woman executed in the United Kingdom. No woman was hanged after her. The date of her death, the 13th of July 1955, marks the closing of a door. In the years afterward, her name became a kind of shorthand for the argument against the whole system. When people spoke of why the death penalty had to end, they spoke of her. The case did not persuade by abstraction. It persuaded because a real person had stood in that dock, and because the country had watched what the law then required. The composure she had shown became part of how she was remembered. She had not fought the facts. She had told the court plainly what she had intended, and she had gone to the gallows without a public collapse. That steadiness, set against the softness of the mercy she was denied, sharpened the unease. A woman who accepted her guilt so completely made the rigidity of the sentence harder to defend, not easier. The very honesty that had sealed her conviction became, after her death, one of the reasons the conviction troubled the nation. For decades, the case sat in the public memory as a settled injustice of an older, harsher time. But it was not quite finished as a matter of law. Her family did not let it rest. They believed that the conviction itself, and not only the sentence, deserved to be examined again by the courts. The passage of years had brought a mechanism that had not existed in 1955. There was now a body whose task was to review possible miscarriages of justice. Where it saw cause, it could send old cases back to the appeal courts. That body was the Criminal Cases Review Commission. Through the commission, the family took the case forward. In 2003, the matter of Ruth Ellis came before the Court of Appeal, Criminal Division. That was nearly half a century after the shooting outside the Magdala. It was an extraordinary thing. A murder conviction from 1955 argued again before the senior judges of a later age. The court had to decide whether the conviction could stand. The judges approached it in a particular way, and their reasoning is the key to the outcome. They held that they could only apply the law as it had stood in 1955. They could not reach back and grant Ruth Ellis the defenses that Parliament had created after her death. Diminished responsibility had not existed at her trial. The wider provocation rule had not existed either. Judged by the law of her own day, the court found the conviction was sound. The jury had been directed correctly for 1955, and the verdict followed from the law as it then was. And so the Court of Appeal rejected the appeal. The conviction of Ruth Ellis for murder was allowed to stand. It was upheld by the same court system that had first condemned her nearly 50 years on. The family's hope that the record itself might be rewritten was not granted. In strict law, the outcome of 1955 held firm in 2003. Yet the judges did not pretend that nothing had changed. They acknowledged in plain terms that the case would very likely be treated in an entirely different way under modern law. A defendant in Ruth Ellis's position today would have the defense of diminished responsibility open to her. She would have the reworked law of provocation to draw on. The violence she had suffered could be placed before a jury. So could the miscarriage caused when Blakely struck her. So could her state of mind in the days she spent sleepless and searching. All of it might reduce murder to manslaughter. The court was saying two things at once. By the law of 1955, the conviction was correct. By any measure the law had since adopted, her case would look nothing like a straightforward murder. That was the paradox the appeal left standing. The judgment did not free her name in the way her family had wanted. It could not, because it bound itself to the rules of her own time. But in its careful acknowledgement, it recorded something from the highest level. The law that hanged her had since been judged unfit for exactly her kind of case. The reforms that followed her death were, in effect, the country's admission that the machinery had failed. The 2003 ruling put that admission into the language of the courts themselves, even as it declined to overturn the verdict. The two findings sat together and did not cancel. The conviction was sound in 1955. The law of 1955 had been changed because cases like hers showed it could not be trusted with a life. Both were true, and the space between them is where the whole meaning of the case lives. A woman was correctly convicted under a law that the nation then decided it could no longer keep. Ruth Ellis remains the last woman executed in the United Kingdom. The revolver fired outside the Magdala that Easter Sunday marked the beginning of the end of hanging in Britain. She never asked to be a symbol. She admitted the killing in a single sentence and expected to die for it. What she could not have known was that her death would trouble the country more than her crime ever had. The law that bound the judge, the jury, and the hangman would not long outlive her. If you found this case as haunting as the nation did in 1955, take a moment to subscribe and turn on notifications. That way, the next forgotten case reaches you. And tell us in the comments which case we should uncover next. The grave at Amersham lost its headstone. The law that sent her there lost its authority. And a battered young mother, hanged on a July morning, became the case that a modern country could not forget.